Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. My name is Dan Balkaran, and I'll be your employment lawyer for the next 30 minutes. That's my name on the screen. As you can see, I am an employment lawyer at Samfiru Tumarkin, LLP, which is, as always, Canada's leading employee side employment law firm. Just a moment of housekeeping. If you have any questions or want to get a hold of us for any reason, you can always do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900, as will be posted on the screen. Okay, so we got questions rolling in. So let's get to them. Please send your questions as soon as you can. There's always a lot of questions towards the end of the session, and certainly I want to get to every question that I can and answer every question that's posted. So, okay. Giovanni asks, I've been working as a custodian for about 3 months. I'm not happy with the position. If I chose to quit, would I be entitled to severance? No. So Giovanni, you're entitled to notice at law. You're most likely provincially regulated, although you could be federally regulated, but you're most likely provincially regulated. And so you're not entitled to any notice in the event of your termination at all if you've been working there for less than 3 months. Over 3 months, you've been terminated, probably entitled to a week under the Employment Standards Act. If you did not sign an employment contract that limits you to the Employment Standards Act in terms of your termination entitlements, then you could be entitled to certainly more. In BC, we have what's called short service employees, where your floor is 2 to 3 months in the event of your termination, and it can escalate for things like leadership position and prolonged period of unemployment. But that's only if you were terminated without cause that you would get notice. Now, and notice, by the way, it's simply a heads up by your employer, and this is all their legal obligation is. Hey, Giovanni, the bad news is we're going to terminate you in 4 weeks. The good news is you're going to continue to work here for 4 weeks and draw a paycheck during that time, and we'll give you time off to look for another job, and hopefully you're not unemployed for very long, if at all. It's all you're entitled to. However, if your employer chooses to terminate you today, then you're still entitled to the notice of your termination, but you can't get it because your employment is being terminated today. And so that notice converts into severance, which is money. It's the money you would have made had you worked during the notice period that you're entitled to. Okay, so most of the time, employers terminate effectively the same day or more or less the same day, and so it's severance that you're entitled to. And so I'll refer to it as severance throughout the balance of this broadcast. But no, if you quit, you don't get anything unless you're forced to quit by the actions of your employer. So if your employer is harassing you and there's a lot of evidence of that, or someone else is harassing you and some other employees harassing you, and you've asked your employer to deal with it and they don't, or your employer cuts your pay by 50% or cuts your hours by 50% or moves you to an office across the country, without something substantial, then no, you don't get any money if you quit. And it's a free economic marketplace. You can always choose to quit and go somewhere else if that's better for you, but your employer doesn't have any obligations in the event that it doesn't have any termination obligations to you in the event that you choose to quit and go somewhere else because quite simply it didn't terminate your employment. Okay. Jordan asks, if my employer decreases my pay by 10% and then does it again later, would that be a constructive dismissal? Well, so 10%, there's a case in BC, and it varies probably by region a little bit. 10% in BC, there's a case that says that, absent more, it's not going to be a constructive dismissal. So if it was a 10% pay cut and a demotion or a diminution in your responsibilities, you were the manager, now you're, supervising one person or something like that, then it would be a constructive dismissal. but 10% on its own, unlikely to be a constructive dismissal in BC. I'm not saying that it wouldn't be necessarily in Ontario, but certainly in BC, that's a tough road. But if it does it again later, right? So you're deemed, if you continue to work, if you did not voice your objections to the first pay cut, and then you continue to work, and then it does it again later, I think that's an interesting argument, because you're deemed to have accepted the first pay cut, but at some point, what are you supposed to do? Just continue to accept these pay cuts? I think that it's very probable, or very possible that is, I shouldn't say probable, it's possible it's a constructive dismissal. There's that same case that I was referring to in BC says that 20% or more is likely a constructive dismissal. Can you aggregate those two together? Well, I think you can also say that through these changes, your employer doesn't seem to want to be your employer anymore. And so I think if you came to me with this, depending on how long the interval is between the two. So if 5 years goes by, no, but if it's 8 months later, I think you on balance, I mean, constructive dismissals are hard, right? You've got to get a court to agree, if it comes to that. You've got to get a court to agree that yes, there was a fundamental change a change to a fundamental term of your employment, such that in effect the employer has terminated you by the change, or the employer has indicated through its actions that it no longer wants to be your employer. And so you've got to get a court to say, yeah, I couldn't, if I put myself in the employee's shoes, I couldn't continue to work there either. So it's got to be a fundamental change or a substantially problematic situation. But I think, a couple of 10% pay cuts equaling a 20% pay cut over a fairly brief period of time, I think that probably gets there for a constructive dismissal. I'd have to take a look to see if there's any analogous cases on point with the delay, 10% spaced out, twice spaced out across time. But I would take that on. I'll put it that way. Jordan, I think you need to talk to an employment lawyer, and I would do so right away. Just with any constructive dismissal, any fundamental change to a term, any change to a fundamental term of your employment that you think might be a constructive dismissal, you're interested in potentially claiming constructive dismissal, you're going to want to talk to an employment lawyer almost immediately. And the reason why you're going to do that is after a couple months, 2-3 months, you're deemed to have accepted the change. So, and then you can't claim constructive dismissal later. So talk to an employment lawyer right away, Jordan. You can see on the screen, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Sam, I don't know what your question is, so please feel free to come back in later. Answer this question. Give me 1 sec. If an employer is late on paying employees, how long are they allowed to be late by? What happens if it happens multiple times a year? Okay, so the employer has to pay you on time. I believe it's covered within the Employment Standards Act. But if you're not paid ever for a particular tranche of wages, your remedy is through whatever the body is that governs employment standards complaints. If you were provincially regulated, if you're federally regulated, you'd have a complaint to the Canada Industrial Relations Board. But I don't think that's a question of what is your remedy through an adjudicative body in the event that you don't get paid. Is there a punishment to an employer for paying late? I don't know the answer to that question. Maybe. I mean, if you take a look at the Employment Standards Act, they don't pay on time, but then they eventually do pay you. Is there some sort of penalty situation that the employment standards regime imposes on employers? I wouldn't be surprised if there is. I have seen items like that in in employment standards decisions. I just don't know. It's not something that's ever come up in my practice. But I think you've got a bigger problem, and I don't know who you are because you haven't identified yourself with a name. But I'll say, if your employer isn't paying you on time, at some point, the absolute fundamental core of an employment relationship is labor in exchange for money. You're trading your labor for money, and if the money part isn't there, at some point, I think not just you, but your colleagues are probably going to look around for a different position, because if you can't trust your employer to pay you, then maybe it isn't the right place for you. I mean, I don't know how good a situation it is. Maybe you have many years there, but not paying you on time indicates, generally speaking, either there's a trust problem for you with respect to the organization, or more likely, the employer doesn't have the money. And if the employer doesn't have the money, that could be a problem down the road for all of the employees that maybe those employees want to get ahead of rather than wait to see what happens. So I would be really concerned about that. Before I was a lawyer, I used to run call centers for major technology corporations. And I can tell you, employees, generally speaking, they can accept one problem with payroll, late paychecks, et cetera. But once you start stacking them, they start to reassess their options very quickly. So I don't know what your name is. Good luck with that. I hope that problem resolves itself. But in terms of holding the employer's feet to the fire, I don't think you have good options. I think that any sort of adjudicative measure by yourself will take months and months and months and months to resolve, and that's not going to help you now. You need your paycheck now. Question from Chow. I was terminated without cause. I've worked with the company for over 30 years, a senior management position, and I'm 65 years old. What sort of severance am I entitled to? It depends on what your contract says, right? If you have an enforceable termination clause in your contract, you could be entitled to as little as 8 weeks. However, if you don't, you could be entitled to as much as 24 months. So obviously, huge swing in what your contract says. So Chow, you're going to want to talk to an employment lawyer immediately. If you want to get a hold of us, please feel free to do so. You can reach us at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Chow, it's too important that, this is a huge swing in value, right? It's a huge swing in value. You need to get a legal assessment of your legal entitlement. You need to do that right away. Okay, so give us a call right away. Seek out an employment lawyer right away. You need to get legal advice immediately, and do not sign anything from your employer until you do. Okay, Sherry says, I've been put on a performance improvement plan, which I've challenged due to unwarranted claims and evidence of discrimination. Oh, so they're saying that you committed discrimination. Okay. Human resources may revoke it. Should I drag things out to maximize earnings or negotiate exit now? Also concerned about future layoffs. Could this diminish my leverage for better severance, especially after voicing these issues? Could I still claim wrongful termination and seek extra pay? I see. So what you're saying is, they said, we don't like your performance, we're putting you on a performance improvement plan, and then you claim discrimination. On the basis of what, Sherry? Sherry's still posting. So Sherry, was on the basis of gender, sex, race, ethnicity, disability, one of the other ones? What is your allegation? I don't see how it's interesting from a negotiation and leverage perspective. That's an interesting strategy, but I don't know race. Okay, so discrimination on the basis of race. I don't see how those two things are connected, right? Like if it's before an adjudicator, where employer says, we don't like your performance, and your response is, you're racist, right? Like those two things are, they're apples and oranges. So, I think if you've claimed discrimination on the basis of race, which is an another way of saying you said they were racist. I don't see how that employment continues, right? So, I mean, it could. I don't know, how long you've worked there for, what your position is, how much you're making, if you have an enforceable termination clause. So I don't know if you want to stay there. I don't know if you have a lot of money coming to you or a little money coming to you. But, once they've said your performance is so bad, we're giving you effectively a last chance to fix it, and you say racism, I don't understand how that employment continues. Like it just doesn't seem like it's going to. I'll say generally, if an employer gives you a performance improvement plan, it really seems to be just a tool to try to get the employee out of their employment without having to pay them so much money on the way out the door. That's what it seems like to me. It's very rare I've found that the employee surmounts the performance improvement plan, completes everything in it, and then remains an employee in perpetuity. Like it seems to be a way for the employer to limit its liability by, having having evidence of a just cause termination, because the employee, we warned the employee, they just weren't fixing their performance. We gave them a performance improvement plan, didn't fix it, so we can terminate them without cause. Normally, you'd be getting 12 months of severance, depending on the situation in terms of the employee's statistics. But we'll give you 3 because we think we have cause. It seems to be a negotiation strategy for the most part. Sometimes I've seen employees successfully complete the performance improvement plan and stay on, but that's certainly the minority. In terms of discrimination, if you've been discriminated against, you would have a human rights complaint. Discrimination on the basis of race can be challenging. In terms of you don't need a lot of evidence to establish a human rights complaint, but you need some. And it's hard, in Canada, rarely is an employer going to come out and put in writing things that are overtly discriminatory. But, certainly sometimes you can look at numbers where, there are 20 managers and 19 of them are men, things like that can indicate discrimination on the basis of certain human rights protected grounds like race or gender or sex or age or disability. But those can be difficult. I think that when you said you alleged discrimination and then they said, hey, we might retract our PIP, our performance improvement plan, I think that no company in today's day and age wants to be accused, particularly with social media, of discrimination on the basis of race. And so I think that your strategy may have been successful in terms of having them remove the performance improvement plan. But, your question was, should I drag things out to maximize earnings or negotiate an exit now? Maximize earnings in terms of earning a wage? Well, you can earn a wage somewhere else as well. I think that, as I said earlier, if they said, we're giving you effectively a last chance to fix your performance or you're out, and you responded with, you're racist, I think the relationship is probably done. And if you can negotiate an exit package, then where you get money, I would do that. But, be careful, because they haven't terminated you, and you don't have a legal entitlement yet. I mean, I don't know what your discrimination complaint is, but you don't have a legal entitlement yet to anything. So this would be a sort of voluntary situation where the parties acknowledge that this just isn't working, and they pay you some money to leave effectively. I would also, Sherry, you can do that on your own, but what I just said is fairly complicated. And my advice, my impression of this is you should get legal advice. So I'll say it again. If you want to get a hold of us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay. Question. Person not identified again. My employer canceled our contract with an equipment supplier. Okay. We are now being asked to supply our own equipment for work. Is this allowed? Do they have to provide us with any compensation for purchasing equipment? I think in the BC Employment Standards Act, there is a provision that says they have to provide you with your equipment. I believe so, but I can't recall. It doesn't come up in my practice ever. I do know that nurses, though, for example, and I mean, that's different. It's a union situation, but they have to supply their own uniforms, and lots of places have that. So I don't know the answer to that question. I think that if you take a look at your Employment Standards Act in your province, assuming you're provincially regulated, you might be able to find the answer there. But let's just say they're prohibited from shifting that cost to you by the Employment Standards Act. And they might not be. I could be misremembering. But let's just say they are. Well, how much is this equipment costing you? A few $100s? Are you going to bring an Employment Standards Act complaint against your employer over a few $100s, which will jeopardize the relationship? Probably not, or at least I wouldn't recommend it, depending on if you want to stay there or not. Does them asking you to pay for your equipment amount to a constructive dismissal such that you have a severance claim? No, I don't think it does. It's not substantial enough. So you're not really left with a lot of good options. I think the best one here, if you can do it, is say to your employer, and not say to your employer, but negotiate an amicable resolution with your employer, or a few of you do that and say, like, I shouldn't say, but I'm not going to tell you how, because this is not a legal, it's not legal advice, and it's not necessarily a legal issue, although I don't know what the Employment Standards Act says about that. But I'll just say that this is the kind of thing that the most effective solution for you and the best solution for you is probably an amicable negotiation with your employer. So I'll leave it at that, because I can't give you any specific direction on that point. I don't know your employer, but that's what, there's not a lot of good options here. And so if you can work it out with them, probably the best thing. Sherry's back. Sherry says that she provided evidence the performance improvement plan was unwarranted. So I'll just say this about performance improvement plans. Every single client I've ever had that has a performance improvement plan has said that it's unwarranted. Right? That's the thing, right? Like, there's a disagreement between the employer and the employee over whether or not the employee's performance is a problem. Employer says that it is, so in effect it is. Now it could be that the employer has political reasons, could be that your manager is out to get you. These things do happen, but they're saying there's a problem and you have to fix the problem. And if your response is there is no problem, I'm not fixing anything, they're going to terminate you for just cause, right? So it's not a great situation, but that's the nature of the employer-employee relationship. There's an incredible imbalance of power between you and the employer. And so you have to work within that. So, Sherry, I'll just direct you back to my previous comments that I said earlier. It sounds like the relationship is done, and that perhaps you may want to negotiate an exit. So, if that's available to you, I don't know if it is. Okay, Jay is here. Considering a landlord may issue notice to enter a suite with as little as 24 hours notice, does an employer have to accommodate you with time to deal with issues like that? I don't think it's an issue. Your employer gives you 24 hours notice, or sorry, your landlord gives you 24 hours notice, complies with its obligations under the Residential Tenancy Act. I assume that's where it is. And then someone enters your premises for whatever the reason, right? If it's a vendor, if it's a showing the suite, whatever it is, I don't see why that affects you don't have to be there while that's happening. You may choose to want to. But no, I don't recall there being anything in the Employment Standards Act or regulations that says that the employer has to accommodate that. I'm open to being wrong about it, but I would direct you to the Act and the regulations to see if you can find something along those lines. But I would assume no. And again, I think your resolution here is amicable it would have to be an amicable one where your employer would be willing to give you that time. I don't, if you feel that you must be there, I don't see the law requiring your employer to do so. It's just not a thing that comes up ever. Have you, oh, this is Jay again, have been given notice and landlord needed to enter the suite in the past? So far, it has not been on a work day, and I'm wondering how that would work. Well, again, I don't see that you have to be there, right? Like the landlord has a key. Landlord is provided you notice saying I'm going to visit on X date, and landlord's going to visit on X date. Now, if you are worried about your possessions, maybe you do feel the need to be there. But I would, if you need to be there, and it happens on a weekday or a work day, maybe your employer will grant you some time to deal with that. Maybe you can pin the landlord down on a specific time, but I don't, there's nothing in the law, I don't think, that can assist you there. Question from Abby: if I have to leave a job due to work overload, would I be entitled to severance? Okay, so my first impression of that is no. Having a lot of work is, it's just parts of lots of jobs. I will say there's a caveat to that, though, and that's if you work for a long time in a position, or at least a couple years or a year, and your workload was this, right? And then the employer just said, well, we're going to triple your workload to that. And you had evidence of that, metrics, that kind of thing. Could that be a constructive dismissal? Yeah, I think it might be. I think that would be a tough case, but I think it certainly might be. I know some of my colleagues have run cases like that. I'd love to see some case law research on that particular point. But is it a change to a fundamental term of your employment? Well, the amount of work you do, sure, that's got to be a fundamental term of your employment, especially if it's not met with a commensurate amount of compensation increase, right? So, if the employer doubled your workload and also gave you a big raise, I don't think you'd have anything there. But if they didn't, and they just doubled your workload, then maybe, right? I talked to an employment lawyer. I think that's going to be a tough one for any employment lawyer to answer off the top of their head, but I have seen people take that type of case on before, and there may be precedents in Canada that support that you have a constructive dismissal. But I didn't explain the first part of my answer here. If there's a change to a fundamental term of your employment that you reject within 2 to 3 months, you may have been constructively terminated. If you get it wrong and you claim you've been constructively terminated, but a court says you haven't been, then you quit and you get nothing. So you need to, from the start, and this goes for everybody, if you think you've been constructively dismissed, do not go it alone. Get legal advice. Constructive dismissals are too hard. Okay, if you want to, and for you, Abby, I would get a hold of an employment lawyer right away. Call us if you'd like. You can get a hold of us at employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. But to answer your question, it may be a constructive dismissal, but must get legal advice. Nigel asks, is there a risk of legal repercussions for discreetly holding 2 full-time remote jobs simultaneously, assuming that they're not direct competitors? Could there be a grounds for a lawsuit if discovered? Well, I think the problem is if the 2 full-time jobs if you're doing them at the same time, you're not devoted to either one as a full-time job would be, right? So if both jobs were 9 to 5, how could you be working full-time for both, right? But if one is 9 to 5 and the other is 6 to, forgive my math, but to 2 a.m., I think you'd be fine, right? So you seem to be running it. I don't know if you are, but if you're running it successfully, then you are. Now, what would happen? I think you'd be fired for cause potentially, and it depends on what's in your employment contract. So a lot of employment contracts talk about that you must devote your full attention and time to this specific job. So you can't have a second job like that. But if your employment contract doesn't say that, then or you don't have an employment contract at all, then I think it would still be cause if both jobs were overlapping in terms of time. Okay, could they go after you for any negligent performance of your job, and try to actually get money from you? It depends on if there were actual financial repercussions to the business arising from this, and I would imagine there wouldn't be. So I think you'd be playing with fire here, but if they were running them at the same time, but depends if they find out, I guess. But would it be cause? I think it would be cause if they were both running at the same time. Almost done. Jay, last question. For performance improvement plans, does an employer have to have one with an employee? I only ever seen that in a contract once, never been subject to one. It's not part of a contract. It's where an employer says, we've warned you, your performance hasn't improved, we're giving you a plan to improve your performance, and if you don't improve it, we're going to terminate you. So it's not part of a contract. It's supposedly a roadmap to rehabilitation for the employee, but really it seems to be that it's a way for employers to limit their liability because they've already decided that this employee is probably going to be terminated, and we can pay that employee less if we can allege that that we had through progressive discipline, we had just cause to terminate his or her employment. So, okay, we're done. Great questions. Thank you, everybody. I'm going to be back in 2 weeks, I believe. So join me in 2 weeks, my usual time slot, Friday at 10:30 a.m. Pacific. Join us on Monday. There it is, on Monday at 1:30 Eastern time with Chris Justice. He is going to be answering all your questions, employment law. And other than that, have a great and safe and wonderful weekend. Thank you again for joining us.